Anybody who works in the criminal justice system at the moment knows one fundamental truth, and that is that it's not fit for purpose. Every day trials don't start on time because interpreters don't turn up, or they turn up speaking the wrong language. Every day defendants are delivered late because of cost cutting, there's less recorders, courts aren't sitting, and the CPS are in absolute meltdown. And the one thing which enables the system to function at all is goodwill. It's the goodwill put in by barristers, put in by solicitors, which allows a broken system to keep trundling on. And what the Criminal Bar Association has decided, and what individual barristers have decided, is that we're going to be removing our goodwill from the system to show the Ministry of Justice just how vital that goodwill is and just how necessary it is to allow the system to function. And the way that we're going to remove our goodwill from the system is by carrying out a policy which has been called no returns. Now, in any criminal trial, there will be one criminal advocate who is initially instructed. They're called the nominated advocate. If possible, they will do every hearing, from preliminary hearing through arraignment through to trial and sentence. But frequently they're not able to because the courts list two cases that they have on the same day. And in those circumstances, what is normal is for one barrister to return a case to another barrister. Now, we don't do that to bolster our own practices. In fact, when we return a case, often we don't get paid. And what we're going to be doing with the no returns policy is removing the goodwill. So in the future, if I have two cases listed for the same day and the court won't move one or other of them, then I will return the instructions to my solicitor, and it will be then for the solicitor to try and find another suitable barrister to cover that return. And the expectation is no other barrister who adheres to this policy is going to take that return. What will this mean? Well, it will mean there will be cases up and down the country which are simply not able to go ahead because there will be no barrister turning up. The policy has already begun to bite. In Liverpool, there were two very serious trials listed to start on Monday. They needed to be returned. No barrister would accept those returns, and so the cases have had to be stood out until October, when the initial trial counsel can do it. On the Midlands Circuit in Nottingham, expected in the first week alone, there's upwards of 80 cases that this will impact on. And the real difficulty for those who manage the courts is today, on the day of action, they've known about it for over a month. Last Friday, there were about 3,000 cases being heard in cases up and down the country. Today, there's 1,171, and it's expected out of those, very few will be able to go ahead. But at least they've been able to manage it and have been able to arrange it, and consequently, many courts aren't even sitting at all. From Monday, it won't be until the judge walks into his courtroom whether he knows the case is to go ahead or not. And as to how long it lasts, well, that will depend upon whether the message is getting out there or not.